Welcome to another episode of A Little Privacy, Please. I'm Jason Kravitz, and I'm here with my co-host, Jenny Holmes. Together, Jenny and I lead the Nixon Peabody cybersecurity and privacy practice. We also host this video series, which we like to call a podcast. We don't endorse specific products on this podcast, and we're not changing that practice today. But there are definitely occasions where we want to bring information to you, to our audience, that's pertinent to a pressing privacy issue. And that's really what we're trying to accomplish today. So unless you've been living under a rock and you're in the privacy space, you know that there's been a bunch of litigation filed against companies that are accused of using software tools to track website user behavior without the user's knowledge and consent. It's commonly called pixel tracking litigation or pixel privacy litigation. Take your pick. Today, we have Alex Proctor joining us. Alex is the Chief Trust and Privacy Officer at Captain Compliance. And that's a privacy technology startup focused on helping organizations navigate privacy compliance and risk management challenges. So Alex, welcome to our podcast, A Little Privacy, Please. So maybe start us out by just sharing with us and telling us about Captain Compliance, what it does, and how it's different from other products that are already out there in the marketplace.
Absolutely. And Jason and Jenny, thank you so much for having me on. I just wanted to say that I've been really looking forward to joining you today. So Captain Compliance is a pure focused privacy technology company. So, Jason, you've already mentioned that we're involved in the world of CMP. We're also involved in things like dynamic privacy notices and data subject request processing with automation. And the one thing that if I was to say that I've learned from this experience of working in this company for several years now, particularly when it comes to the CMP space, is this is an area that is extremely difficult to get right. It's not always obvious at first glance. You think these things consist of a pop-up on a website and a couple buttons. How hard can that be? But the reality is that the level of integration that's necessary to actually meet the standard that's necessary to have a maximally defensible website with regard to this wiretapping litigation, and also to look good under the eye of scrutiny of something like a state regulator, it's a very high bar. And there's considerations to think about, including how you handle cookies and scripts. And, those are not handled in the same way. And you're dealing with integrations with things like Google consent mode. And, if you're a Shopify shop, you're dealing with Shopify API integration. And there's just so many opportunities to get things wrong. So the nice thing about this company that I really enjoy is, I've been on the other side of things. I was buying, privacy technologies in my past, and I never felt like I had time to truly invest myself in this sort of technology and understand it. I was never quite comfortable with my configurations. So what I'm loving about this company is being able to take on a lot of that load for our clients and give them the peace of mind that their technology is going to work correctly. In the event that it gets scrutinized. I'll do a quick screen share here. And what I'm going to do is just show just a couple, different aspects of our application, just to give a little bit of color to what we do. I'm not going to be going through this in detail, but I just want to give a little bit of a taste. So what you're looking at here is our main dashboard. There's several different functions that are a part of our platform. I mentioned the CMP thing, but also dynamic privacy notices and data subject request processing and more. What I really wanted to show is the fact that we can create these beautiful these banners. My favorite example to use is my wife's photography website, so I can give you some behind the scenes look at some things I couldn't do for a client. But we'll create an excellent looking banner that matches the look and feel of your site. We'll make sure that it contains no dark patterns or deceptive designs, that we're given good granular options, and that ultimately when you want to go and you want to interact with the website and declare what your preferences are, that we actively will enforce that tracking preference, as you've just seen here. And then the other two things that I have an interest in mentioning, one of them is we do these dynamic privacy notices that I've been mentioning. So the idea there is that if you subscribe to our platform, we make it very easy to maintain a high quality privacy notice. And we do this by helping generate content, identifying what needs to be in the notice, making it easy to customize, and even making certain sections contextualized to the visitor. So if I'm sitting in a certain state that's passed a privacy law, for example, we had Rhode Island as one of the more recent states, you'll be able to deliver a disclosure that's targeted for that visitor.
Sorry, just have to say, of course, have your privacy attorney check that when
Oh, of
before it gets
course.
put on your website.
Absolutely critical step. Absolutely critical step. And then the last aspect of is the data subject request handling. So an idea where I can show you this is something like this. You'll create a portal, and then we will actually automate the fulfillment of the requests through backend API connectors and such. And this scales up. So if you're a data broker and you're in California and you've got new drop requirements, you'll be able to use us to integrate with the drop platform. We go very deep here. So I didn't want to show too much just in the interest of time, but that's a general idea of what we do.
That's great. Thank you.
So, Alex, you had mentioned previously that this is a really hard area to get right. Why do you think so many other firms and other companies struggle to get this right?
I think it's because in an effort to make things easy, it can be very easy to not configure website consent to the degree that it needs to be configured. So for example, most consent technologies operate in multiple layers. And the two that I'd like to explain it is you typically have like a cookie auto blocking layer, which will do things like delete cookies from your browser if somebody opts out, kind of control that browser level storage. And then separately, you'll have the ability to do things like gate scripts. So this is where maybe in your tag manager workspace, if you're using something like Google Tag Manager, you would put logic in the triggers where your tags get fired and have that look for consent logic. Now, it's very easy to drop the script on a website and make sure the banner looks good, and you might be partially there. You might have a somewhat functional auto blocking level deployment. But these privacy testers, as they like to call themselves, will be testing much more than just cookies, and they'll be looking for network transactions to third parties that don't rely on cookies, for example. And so you do need to go somewhat deep to be able to truly, maximize your defensibility on your website. And that does involve some manual setup.
So, Alex, why are these tracking cases so difficult for companies to navigate and to avoid?
There's several reasons. I would say that one of the reasons is because all of this private litigation is happening. It's generally not happening via our modern privacy laws, which generally don't give a private right of action, except for very limited cases. What they're doing is they're using old wiretapping laws, mainly wiretapping laws. And these laws are from literally as far back as the 60s. That's when, the SEPA's California Invasion of Privacy Act is literally from before the internet got created. And so they do have the private right of action. There are these cases where these old laws are being used to challenge the most modern website technologies available. And the problem and the difficulty is that the courts are just completely split on how to deal with these sorts of allegations and claims. Some of the time, these cases get thrown out, especially in certain jurisdictions, while in others, they're regularly allowed to proceed. And when they're allowed to proceed, the case law can differ. So, for example, in the most extreme cases, there's been case law out of California where courts have found that the concept is that retroactive consent is invalid. So This is like, whoa, this is an extreme bar to meet. It's very, it's actually pretty much similar to European Union style GDPR. You must opt in prior to firing any trackers. That's actually the stance that some of this case law has come out to. And because companies really care about their marketing data and their targeted advertising, and to run a model like that, an opt-in model can be, not great for the marketing department. It creates a lot of risk-based decisions where companies need to navigate whether that residual risk is worth it when they're choosing between the opt-in and opt-out models. It's just tough to deal with because of the ambiguity.
So it sounds like this is another one of those situations that we see a lot in my world, in Jenny's world, where the law just can't keep pace with technology, and therefore the courts can't keep pace with technology. They're sort of constantly trying to catch up.
Exactly.
I think you hit the nail on the head. One of the issues that we come across a lot is explaining what we believe to be legally a best practice or legally required versus weighing the needs of marketing and understanding that marketing has a really important function on websites and the data collection points. Do you have any tips for navigating that and how to weigh marketing needs versus legal risk?
Yeah, absolutely. So it is 100%, it needs to be a business risk decision first and foremost, because I can tell you just from our internal data, most people do not interact with consent banners and that type of technology. You'll be lucky to get 5% of people click allow and 5% of people click reject. Most people are going to be stuck with the default policy. So if it's restrictive, it's going to be a major impact to marketing. And for many companies, they simply can't tolerate that unless they're in a region where it's absolutely necessary. So that's the risk decision to be made. The other aspect is you do see some companies who are very sensitive to the litigation trying to find incremental things that they can do to slightly improve the situation. So what I mean by this is one example would be instead of running an opt-in model in all states, which is very aggressive, a company might choose to run the opt-in model in California and maybe in some of these other two-party consent states where we're starting to see similar claims, places like Florida, but leave most of the U.S. opt-out. That's one potential, it's a compromise all around, but that's the type of decision that's being made. And then there are little things that companies can do just purely from a UI perspective. It can be dangerous territory because you never want to have what's called a dark pattern or a deceptive design with your banner where you're manipulating decision making. But you will see companies do things like if they're in the opt-in model and they want to maximize the interaction rate, they might put the thing right in the middle of the web page. They might make you interact with it before you visit the site, things like that. And they only do that to try to preserve at least some analytics while still doing the opt-in model.
What is it that companies can do to assess whether a solution like Captain Compliance is actually providing the legal protection that they desire, right? The reason that they're trying to do this in the first place, as opposed to just checking off a box and hoping for the best?
Great question. I think the first thing that I want to emphasize is that if you're ever in a position where you're validating the quality of your CMP deployment, you want to be working with your legal team, your legal colleagues, the attorneys that you work with. Somebody with a legal background should be providing a critical eye on your CMP deployment, because a lot of the times these technical aspects of your deployment will require legal analysis. So with that said, the other thing that I would say is that there should be ongoing review. So this can take different forms. It could take the form of a quarterly assessment. It could take the form of perhaps a technology that performs ongoing monitoring where it flags things and submits them for legal review. There's third-party companies that can perform some of this work for you. But the main theme is that somebody should be doing ongoing review, definitely at the quarterly interval, perhaps more frequently, with legal involvement.
That is going to do it for this episode of A Little Privacy, Please. Alex, thank you for joining us, and we'll see you next time.
Thanks for having me.